Dear learners, welcome to video lecture series 17 for BA first semester Political Science in the paper of Introduction to the Political Theory. I am Dr. Deepak Kumar Kashyap, Assistant Professor at Pandit Sundarlal Sarma Open University. Law referred to a system of rules established by a recognized authority to regulate behavior and maintain order in society. It ensures justice, protects rights, and defines duties. The source of law include legislation made by the legislature, customs and traditions, judicial decisions, and precedents. And the law can be classified into various types such as civil law, criminal law, public law, and private law. And each type serve a specific purpose in governing relationship within society. Through this lecture, we can understand law in terms of its meaning, sources, and classification, which help us to see how it functions as the backbone of an organized and stable society.
Theory, law is considered indispensable for the existence of an organized society. Human beings are social by nature, but social life inevitably leads to conflict of interest. Law provides a structural framework to regulate these conflicts. It ensures predictability, stability, and order. Without law, society would fall into a state of anarchy where power rather than justice would dominate. Thus, law transforms society from a condition of uncertainty into an organized political community. Law can be understood as a body of rules recognized and enforced by the state. However, from a political theory perspective, it is more than just rules. It is an expression of power, authority, and legitimacy. Law reflects the will of the state and shapes the relationship between the rulers and the governed. It determines rights, duties, and the limits of authority, thereby playing a crucial role in structuring political life. Different scholars have provided different interpretations of law, which reflecting diverse philosophical perspective. John Austin defined law as the command of sovereign backed by sanction, emphasizing authority and coercion. John Salmon views laws a body of principles recognized and applied by courts and highlighting the role of judicial institutions. And Thomas Dixon Holland defined law as general rules of external human conduct which enforced by political authority. And these definitions collectively show that the law is deeply connected with power, institutions, and social order. Law possesses several essential characteristics. It is universal in applications, meaning it applies equally to all individuals within a political community. It is enforceable through institutions such as courts and police. It is backed by the authority of the state to making it binding in nature. Additionally, law involves sanctions ensuring compliance from political perspective. These characteristics demonstrate how law functions as an instrument of governance and control. The purpose of law extends beyond mere regulations. It aims to maintain order, protect individual rights, and ensure justice to promote social welfare. In political theory, law is also linked with legitimacy. It justifies the authority of the state. A legal system that is fair and just gains public acceptance will unjust laws may lead to resistance. Thus, law plays a crucial role in balancing authority and freedom. Sources of law refer to the origins from which legal rules derive their authority and content. In political theory, studying the sources of law helps us to understand how legal systems evolve and how power is institutionalized. It shows that law is not static but dynamic and shaped by historical, social, and political forces. Sources of law are broadly classified into formal and material sources. Formal sources give legal validity to rules, meaning they make them officially binding. Material sources provide the substance or content of law, such as customs, traditions, and social conditions. And these distinctions help us to understand both the authority and the content of the legal system. Custom is the oldest and the most fundamental source of law. It consists of long standing practices that have gained acceptance in society. In earlier societies, customs regulated behavior even before the emergence of the state. Over time, many of these customs were recognized and enforced by political authority, becoming formal laws. And this shows the deep connection between society and laws. Religion has historical played a major role in shaping laws. In many ancient societies, laws were considered divine commands. Religious texts and beliefs guided social behavior and influenced political authority. Even today, in some societies, religious principles continue to influence legal system, and this highlights the moral and ethical foundations of law. Judicial decisions are an important source of law, especially in modern legal systems. Court interprets laws and apply them to specific cases. Their decisions create precedents which become guiding principle for future cases. And this process ensures consistency and adaptability in the legal system, which allowing law to evolve with changing circumstances. Legislation is the most important source of law in contemporary states. Laws are formally enacted by legislative bodies such as Parliament. These reflect democratic principles as elected representatives, which creates laws on behalf of the people. Legislation provides clarity, uniformity, and authority to legal systems. Equity equity refers to principles of fairness and justice that supplements strict legal rules. Sometimes rigid application of law may lead to injustice. In such cases, equity allows flexibility and ensures that justice prevails. In political theory, equity represents the moral dimensions of law. Classification of law means dividing it into categories, which is based on the nature and its function. This helps in understanding the complexity of legal system. In political theory, classification allows us to analyze how law operates in different spheres of life and governance. In public law deals with the relationship between the states and individuals. It includes constitutional law, which defines the structure and powers of government, and administrative law, which regulates state actions. Public law is central to political theory because it deals with authority, power, and governance. Private law governs relationships among individuals. It includes areas such as contract law, property law, and family law. It focuses on individual rights and obligations rather than state authority. This distinction between public and private law is essential for understanding legal system. Civil law deals with disputes between individuals such as property disputes or contractual disagreement. Its main aim is to provide remedies and compensation rather than punishment. It also ensures that the individuals can resolve conflicts peacefully within a legal framework. If we talk about the importance of law, law is basically it simplifies the study and application of legal systems. It helps legal professionals and students to understand different aspects of law more clearly. In political theory, it also helps in analyzing how law functions within the broader political structures. To concluding, law is a fundamental concept in political theory. It is not only a system of rules but also a reflection of power, authorities, and social values. It originates from multiple sources such as custom, religion, legislation, and judicial decisions. Its classification help us to understand its structure and function. Ultimately, law serves as the foundation of an organized, just, and stable society. Thank you. Thank you so much.